Hello everyone and welcome back to LiveLaw Academy. In this session, we will discuss a latest judgment related to Res Judicata. Res Judicata is an important principle as far as civil litigation is concerned. And we all understand Res Judicata in its classical sense, that it means that a particular issue on which a final decision has come, any issue which is finally decided, which is heard by the court and finally decided, it cannot be re-litigated. Things cannot be re-agitated again and again before the court of law. And the idea is to prevent unnecessary vexation of the parties. The idea is to bring certainty in the overall civil litigation. Right? This is the classical sense of the principle or the doctrine of res judicata. Now, today, the case concerned is related to application of res judicata to the impleadment proceedings. Right? Impleadment means when a party is impleaded in any capacity in the suit. You can note down the decision Sultan Sayyid Ibrahim versus Prakashan. Sultan Sayyid Ibrahim versus Prakashan, 2025 LiveLaw, Supreme Court 622. Supreme Court 622. Now, this case was regarding specific performance of contract. The contract was concerning a piece of land in Kerala. Agreement was entered into. As per the terms of agreement, it was decided that the consideration will be 6 lakhs. And upon the complete payment, part payment was done. Upon the rest of the payment, a sale deed was supposed to be executed by the parties. So initially 4.5 lakhs were paid, and upon the rest of the payment, 1.5 lakh, the parties were supposed to complete the transaction by executing and getting the deed registered. That was the transaction. That was the overall contract. Now, what happened? The purchaser was ready to pay the rest of the amount, but the seller refused to execute the document. And this led to the institution of a suit before the civil court. Initially, proceedings were ex parte. A decree was set aside later on, and then normal. And in 2003, there was a decree in favor of the purchaser, in favor of the buyer. Right? When the execution application was made, execution proceedings, they started. The seller, she died in the course of those proceedings, and then application was made to implead the legal representatives. Now, Order 22 of Code of Civil Procedures, Code of Civil Procedure allows such an application to be made. You can call upon the legal representatives of a particular party who is no more, but the cause of action still survives. And here the decree was already passed and they were into the execution proceedings. So they were impleaded. Notices were issued to the representatives, legal representatives, including the appellant in this case. That was before the Supreme Court. And over a period of 3 to 4 years, every possible move, every possible trick that is there in the book, because of which you can delay the execution proceedings, every possible trick was pulled out of that book. And during all these proceedings, during all these years, after the impleadment application was made, 4 years elapsed, roughly 4 years. During these proceedings, appellant was participating in every single proceeding, including an application moved by the legal representatives claiming rescission of contract under the provisions of Specific Relief Act. He was also a party to that. He He was party to every single proceeding, but nowhere he objected to his impleadment as a legal representative. He was completely silent. He was completely silent. And later on, after 4 years, he moved an application under Order 1, Rule 10. Order 1 deals with the parties. Order 1, Rule 10 empowers the court to add or substitute or, uh, you know, release a particular party from the proceedings. Strike out the party. And this can be done at any stage of the proceedings. The court is empowered to exercise power under Rule 10 at any stage of the proceedings. Now, this application was moved under Order 1, Rule 10, claiming that he was the tenant on the suit property. And since he was tenant, he cannot be impleaded here because his rights cannot be determined in the capacity of legal representative, but separately. So this was another last move to stall the execution of the decree, which is actually in favor of the plaintiff, in favor of the buyer, right? The trial court pointed this out, that there is lack of bona fide as regards this application under Order 1, Rule 10. Also, when notices were issued that an application has been moved against you under Order 22 to make you a party, to implead you as a party, as a legal representative, then objections could have been raised at that stage. And in fact, Order 22 Rule 5 empowers the court that if the question arises that whether a person is a legal representative or not, that can be decided by the court, which means objection could have been made and that objection could have been decided. But for 4 years, no such objection was made. He has waited silently, right? So this amounts to, this ground could have been raised at that stage. And the same was not raised. And now at a subsequent stage, after 4 years, you are raising the same plea. You basically want the court to go back to the earlier stage. That was 4 years prior. The trial court said that this amounts to constructive res judicata. A matter could have been raised, objection could have been raised, you have kept silent, hence constructive res judicata will apply on you in the same suit, though normally we see that res judicata as application in subsequent suit. But res judicata can also apply in the same suit at different stages. The court cited numerous decisions to back this, right? So trial court rejected this application, right? Dismissed this application. Then the matter was raised before the High Court. The High Court also found the trial court's decision to be sustainable. The court did not find any wrong in the reasoning of the trial court judge. Then matter reached to the Supreme Court. The Supreme Court has also clearly in this judgment highlighted that this is actually another trick on the part of these legal representatives to take the fruits of the decree that has finally come in favor of the buyer. He has kept silent. And you cannot say that he was not there. He was not aware of what was happening before the court. He was there. He participated in every single proceeding, including the proceeding for rescission made by, initiated by the other legal representatives, his own siblings. So what was he doing? He was sleeping on his rights. And it is a clear-cut policy of the law that if you sleep on your right, then your right will slip away from you, right? Hence, constructive res judicata. That is the philosophy behind constructive res judicata. You will find this in explanation number 4 of section 11. And even otherwise, if explanation 4 had not been there, this was a settled position that matters which could have been raised, objections which could have been raised, but the same were not, right? They, though not specifically raised, they will be deemed to be directly and substantially in issue and have become final. So the impleadment proceedings upon an application under Order 22, they have become final. You could have raised objection, but you did not. So your status as a party in this suit, in the capacity of legal representative, stands finally decided. Hence, constructive res judicata, you cannot relegate back now. You cannot ask the court to take a step back and decide the matter which could have been decided 4 years earlier. So you are not coming with bona fide intention. You are actually stalling the execution proceedings, right? This was actually a very interesting case, and the starts its judgment. The Supreme Court starts its judgment by pointing out what exactly is the problem with the civil litigation in this country. Some interesting observations, right? I will advise you that if you do not have the time to read the entire judgment, we have discussed it. Uh, Still, you must read the first two paragraphs of this judgment, right? Very interestingly written, and pointing out that uh, that a person who diligently is trying to enforce his rights, but the procedural hurdles with which he is met during the entire process, right, that can take away the you know fruits of the litigation. Also, the person can also become, what confidence will he have on the entire system, right? See, I'll read the paragraph for you. Second and third paragraph. Second is more relevant. The path to justice is often winding, shaped by the weight of hierarchy of the procedure. The seeker, weary yet resolute, climbs each rung of the judicial ladder. सीढ़ियों पर जो बना होता है वो एक एक करके आप चढ़ तो रहे हो, only to stand at the summit, which means at the top, with the hope overshadowed by the fear of denied relief. The respondent before us embodies this relentless pursuit, a traveler in the quest for justice, yearning for its elusive embrace. Right? So, court was conscious about these things, and hence it did not allow the appeal. Right? Thank you very much for joining me today for this very important session. And if you have any doubt, then let me know. I will be more than happy to take them. Res judicata, though it seems to be a simple provision under Section 11, but it has a very, very wider scope and very important role to play in bringing certainty in the litigation, and installing the stopping the delaying tactics on the parts of litigants. Right. So, what is the takeaway from this judgment? That you should raise the objections timely. Sometimes, if you remain silent, then that silence becomes your loudest admission. Secondly, res judicata applies not only in subsequent suits, it can also apply in the same suit but at different stages. Okay, you want me to tell you the title of the judgment again? Please note down. Sultan Sayyid Ibrahim versus Prakasam, 2025 LiveLaw, Supreme Court 622. That is the full citation of this case. Right? Okay. Thank you. Thank you so much. Have a good day ahead. And we'll keep on meeting again and again with some important topics. See you in the next one.